Hello, everybody. My name is TJ Scott, and I'm an estate planning attorney with the law office of Timothy J. Scott. That means that I help people get their affairs in order. I help people plan for what's going to happen after they pass away, or what happens if they become incapacitated before they pass away. And I am so happy to see so many people joining me here today. We're going to be talking about something that I know is a difficult topic for a lot of us, but I also believe that knowledge is power. And today I want to empower you, I want to educate you, and I want to give you some peace of mind around this difficult topic so that you can know what to expect and you can know what to expect for your family in particular. So today I have a lot of valuable information to share with you and some valuable offers that I'm going to be making at the end of the presentation here as well. The best way to learn is to be present here with me right now. This presentation is going to take about an hour, and I encourage you, you've already set this hour aside. I encourage you to turn off any distractions around you. If you have another tab open, if you have the TV on, something like that, I really encourage you to give yourself this time that you've set aside to focus in and learn about this topic. There are a lot of legal terms. There's a lot of legal information that I'm going to give you. And it can be dense, it can be difficult to learn, but I'm going to make it as simple as possible. I promise you that. And I can tell you, your future self is going to be really glad that you took the time and set it aside, didn't have other distractions, and you were able to focus and devote yourself to this information here tonight. And if you stick around until the end, I have a couple of offers that I want to make you. One offer is a free virtual one-on-one meeting with me, where we can get very specific and talk about your family and talk about your assets, talk about exactly what would happen in your case if you passed away today. What would happen with the estate plan that you have in place, if you have an estate plan in place, or if you haven't written an estate plan, what would happen with the state of Minnesota's estate plan? How would that govern the assets that you have? Plus, I have a bonus gift that's going to make it even easier to get a custom tailored estate plan done for your family, to give you that peace of mind for your family. I have a couple of poll questions here that I'm going to ask. The first question that I have is, do you have an estate plan? I'm going to launch this right now, and I'll share some information about the findings. Hopefully it's popping up here. An estate plan includes a lot of different things, and these are just some of the tools that we use to execute a full and complete estate plan. So oftentimes an estate plan will include a trust, not always. Oftentimes an estate plan will include a will, but again, not always. Oftentimes estate plans for people who have minor children will include guardianship nominations, and those are really important if you have minor kids. They might include healthcare directives and powers of attorney. Those govern for what happens if you become incapacitated during your lifetime. For example, if you're in a coma or if you're suffering from dementia, who gets to make healthcare decisions for you? Who gets to make financial decisions for you? And then beneficiary designations is an important part of an estate plan, making sure that you have those beneficiaries set up in the right way. And I'm seeing almost 50-50. About half of the people have an estate plan, about half don't. And I'm not too surprised to hear that. That's pretty typical, actually. And it's even gravitating more towards the number that I'm kind of expecting. Let's see. About 70% of people here in the United States don't have an estate plan, and there can be all kinds of reasons that we haven't done estate planning. I'm going to share another poll here. If you don't have an estate plan in place, or if you haven't updated your estate plan in a while, or if one of these just resonates with you, I hope that or multiple resonate with you, I hope that you'll click on the button and share with me either why you don't have an estate plan in place or what resonates with you. Maybe you've been too busy, and I totally get it. As a father of 4 and somebody running their own law firm, busy describes me. I'm busy every day, and I totally understand that. If that's the case for you, I want to commend you for being here tonight. And I'm seeing a number of people saying, yes, I am just very busy. Completely understand that. I completely understand where you're coming from. But again, I want to commend you on being here tonight, because you are taking the time to to take the first step on this process. You're getting momentum going so that you can get this taken care of for the people that you love. And maybe you feel like you're too young. I'm not seeing anybody who's saying that they're too young, but really, and that makes sense to me because anyone over the age of 18 should really have some kind of an estate plan in place. They recently helped a young woman, and her husband had passed away and left kind of a mess for this wife and for her two daughters. But it didn't have to be that way. You know, it's never too early to get an estate plan in place. And in fact, I'll speak to that a little bit, what kind of an estate plan an 18-year-old should have, just kind of foundational documents to make sure that things are covered. Maybe you feel like estate planning is too expensive. And I'm seeing a number of people say, yeah, I'm worried about estate planning being too expensive. And before word processing, estate planning really was just for the wealthy. But that's not true anymore. Estate planning today is really for everybody, and everybody can afford and everybody should have an estate plan in place. And I will talk specifically about exactly what you can expect to spend on an estate plan, what you can expect a do-it-yourself estate plan to look like. I'll talk about all of these things. Plus, again, I have some bonuses at the end that are going to make it even more affordable to get a custom-tailored estate plan in place for your family. And I do see somebody fessed up. They're worried about jinxing themselves. And I can assure you, I have done dozens, in fact, I've done hundreds of estate plans, and I have never seen a correlation, or I've never seen causation between somebody getting their estate plan done and having something happen to them. I've never seen correlation. I know it, of course, would happen in any Hollywood movie. It would happen in any TV show, but I just haven't seen that evidenced in my own practice. So hopefully that puts your mind at ease a little bit. All right. Next question, if you have an estate plan in place, or if one of these things resonates with you, please share what that is. What are you hoping to learn here today? What kind of information do you want to come out of this with? And I know I've had some questions, and I'm hoping that some additional questions are going to come in, either through the chat box or through the Q&A. But I'm seeing some people ask, is an online will okay? And I'll definitely talk about that. I'll talk about what a do-it-yourself will can do and what it can't do. And I'll talk about who it might be for and who it might underserve, and whose family might be hurting if all they get done is a do-it-yourself will or an online will. Maybe you're wondering, you know, I did an estate plan, but it's been a while. It still names guardians for my minor kids, and my minor kids are now 30 years old. You're wondering, is my estate plan outdated? And I'll talk about that. I recommend having your estate plan reviewed every 3 years. I know it's not easy to do that. It's not easy to get in the cadence of having that review every 3 years. But it's important because there are changes in our family, there are changes in our assets, there are changes in the law that need to be reflected in your estate plan to make sure that your estate plan is still doing what you want it to do. And maybe you're here because you just want to have a better understanding of your plan, or just a better understanding of estate planning in general. And that's a fantastic reason for being here as well. And I really welcome you. Again, if you have something that you want to offer in the chat or in the Q&A box, I'll watch and monitor those and make sure to tailor this presentation to those people who are joining me and those people who have questions here tonight. Just want to tell you, you are in the right place here tonight. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you've done an online will or fill in the blank will, but you're not sure that it's going to work for the people that you love. And you're in the right place if you're nervous about how much this is going to cost. Again, I'm going to speak directly to that point here in a little bit. And I'm going to give some bonuses that are going to make it easier to get a completely custom tailored estate plan done for the people that you love. I see somebody saying, how do I make sure my children don't have to go through probate? That's a fantastic question. And I'm going to speak directly to that point here in a little bit when we talk about probate. I also see somebody else was asking about the organ donors process. And that's I can speak to how those elections are made, and I can speak how to make those elections effective. But as far as the actual organ donation process, That's a little outside of what I typically talk about. It's a little specific for what I usually talk about. But it is a good question. If it's something that you want to bring to me in a private session, I would encourage you to do that, and we can talk more about it. Anyway, you are in the right place here tonight, and I want to thank you for being here. The reality is, estate planning isn't about us. It's about the people that we love. And here on the screen are 3 of my 4 kids. This was a picture taken before my 4th was born, but I have here Margaret, Ben, and Elizabeth pictured. And my wife and I recently updated our estate plan. It's been a little while now, and we probably should take another look at it again. But we recently updated our estate plan, and we realized it wasn't really about us. It wasn't going to bring us extra wealth. It wasn't like a money-making venture, passive income venture, anything like that. We were doing it for the kids. We were doing it for the people that we loved, our family in general, to make sure that they were cared for in the case that something happened to us. And the reality is that your loved ones are going to know whether you lived up to your promise to take care of it after you're gone. And you want to make sure that they are taken care of and that you have taken care of it for them. So here are the things that we're going to talk about today. We're going to talk about planning for incapacity. We're going to talk about planning for when you pass away. Incapacity planning means who can make financial decisions or healthcare decisions for you in the case that you can't make them for yourself. Planning for when you pass away might include guardianship if you have minor kids. It may include planning for probate, and the time, cost, and public nature of probate often make it something that people want to avoid. They want to avoid that court case that happens after they pass away. We'll talk about planning for estate taxes. Talk about planning to make sure that none of your property becomes unclaimed property and ends up sitting in the Minnesota Department of Unclaimed Property and not going to the heirs that you want to receive. Then we're going to talk about intangible assets as well, and how you can pass along your intangible assets in a meaningful way. And I see somebody asking, my mom was just diagnosed with dementia. She's declining quickly. Is it too late for a will? And there are, this is something that is very specific and is very fact specific. What you're looking for is a term called capacity. You want her to have the capacity to know her in general, what her wealth is, to know who are her family and who are the people that surround her and the people that she loves, and also to understand what she's doing in the legal document connects those things. It's related to her wealth, it's related to the assets that she has, and that she is conveying that in some meaningful way to the people that she loves. And so that's really the key things that you're looking for from capacity. It's a difficult thing to assess without being near that person or without having more facts about that person. But in general, I would counsel get it done as soon as you can. Try and get things in motion. Have an attorney who can evaluate whether she has capacity or not there in the room, to be able to make notes and say, she understood this, she remembered this, but I would get it started soon if she's been diagnosed with dementia and she's declining quickly. Thanks for the great question, and I'm really sorry that you and your family are going through this right now, and that she's going through this right now. So before we jump into the entire presentation, I want to tell you just a little bit more about me. This is my family, and my family is really my whole world. And we live in Bloomington, Minnesota. This is my wife, Tobin, and myself. And then from left to right this time, it's Elizabeth, Margaret kissing the baby. The baby is Bridget, and that's my son, Ben, me holding him back so he doesn't jump in and kiss baby as well. So again, my family is my whole world. And again, we live in Bloomington, Minnesota. I graduated from the University of St. Thomas School of Law in 2012 near the top of my class. And the very next day, my son, Ben, was born. I found a job with a small estate planning and tax preparation law firm right out of law school. And I loved the clients that I was able to work with, but sometimes I didn't feel like I was providing my clients with the value that they deserved. And so a little after 3 years with that law firm, I ended up leaving. And this is actually a picture from my last day there. Someone has to graduate at the bottom of the class. Now, this is something that has stayed with me. It wasn't said about me. This was actually said about a very negative experience that my parents had working with an estate planning attorney who helped my grandmother. And in particular, I remember my mom saying, someone has to graduate at the bottom of the class. And there's a big reason for that. I don't actually think it was this attorney's knowledge or intelligence, but I think it was the model that this attorney was practicing under. And I call it a faulty model. I call it planning for death. And it's not really helpful to have a well-drafted estate plan to be planning for death. You have to plan for death, but the planning for death model is not helpful for people. So I know not everyone has minor kids here tonight. And in fact, let me pop up a poll and just find out how many people do have minor kids. So this is just kind of a demographics poll. If you would go ahead and answer it and kind of let me know where you're at, it'll help to inform how much time I spend talking about minors and minor kids and how much more time I spend talking about more general things. I see a chat question. Can a family member be present with an elderly parent, excuse me, when they meet with the lawyer if they're capable of approving it? Absolutely. And some attorneys get a little skittish about having a child or having someone who might have some influence on that person in the room. I can tell you from my experience what I do. I generally go and I meet with the person. I meet with them in front of the kids, and we have a conversation, and then I send the kids out of the room, and I just sit down face to face with my client, and I say, listen, tell me about this. Is this really what you want? Is this really the situation? And just talk to me about why that's the case. And it can be difficult. Sometimes people have difficulties conveying and communicating. And I understand, there are a lot of kids who are really being very helpful, but we also know that there are, unfortunately, some individuals out there who would exert undue influence if they could, and would pressure mom or dad into doing an estate plan that doesn't really benefit mom or dad, or doesn't really capture the wishes of mom or dad. And that's why it's so important to make sure that the client's wishes are coming through, or that the individual who's doing the planning, that it's their wishes that we're acting on, and it's not the kids' wishes. But again, it's a lot of parents when they are at a certain age become really reliant on the kids, and really reliant on the kids to help them communicate. And so I don't think that it does a service to anybody to just exclude the kids entirely from the planning process, especially when the parents have come to rely on them in such a way. Okay. So I see actually relatively few people have young kids here tonight. And thank you again for sharing with me in that poll. So I'm going to talk a little bit about guardianship, but I'm going to move kind of quickly through it. And the first thing that I want to talk about is short-term guardianship. And the way to think about short-term guardianship is you have the kids at home with a babysitter. There's no plan in place. Something happens, mom and dad don't come home. What is going to happen? Well, the babysitter is going to call the police. The police are going to come onto the scene, and likely the police are going to see that the babysitter can't stay with the kids. There is no legal documentation about who can take the kids and who should have the right to take the kids. And the safest thing for those police to do is to call Child Protective Services in until someone else can make the decision. Maybe it's a judge making the decision in a court about who has guardianship and who has the right to take the kids. But really the safest thing, the least liability for the police, is to call Child Protective Services in. And this isn't to badmouth Child Protective Services at all. I think that they have a very difficult job that they're doing. But I can tell you, I don't want my kids to have to spend a moment with Child Protective Services. I don't think that that is a situation where they would thrive. And so it's very important to make sure that you have something in place. You have a plan in place, you have documents in place that tell everybody exactly where those kids should go and who can watch those kids until the long-term guardians can take custody and make sure that those kids are cared for. On the other hand, there's long-term guardianship, and that's who is going to raise the kids until the age of 18. If they're minor kids, if they are 10 years old, who do you want raising those kids? Where are they going to flourish? Where are they going to thrive? Who is going to love them in as close a way as you love them in order to make sure that they have a good upbringing, as good an upbringing as possible without you until the age of 18. And if you don't have a plan in place, if you don't have minor guardianship designation in place, then there is a plan. And unfortunately, the plan is that a judge is going to decide. And it might be a plan that you don't like. And the reason is if Uncle Larry has his own house and Uncle Larry has a steady job, well, Uncle Larry might get the kids, even though you know Uncle Larry shouldn't be anywhere near the kids. Whatever the case might be, oftentimes I talk to families and they say, you might think that we would want the kids to go to this person, but really we don't. We really want this person to be the ones taking our kids. They're just more like us. They enjoy the same things. They believe the same thing about punishment, or they believe the same things about spirituality. Whatever the case might be, you know where your kids would thrive. And it's really important to make sure that you get that documented so that a judge can see it and a judge can grant that guardianship nomination that you have asked for your kids. All right. The rest of the time, we're going to be talking about assets and less about minor children, since, like I say, most people either have grown kids or some without kids here as well. So the first thing that we want to talk about is probate. And if you have no estate plan in place, or your estate plan is a will-based estate plan, then the state has a plan for you. And that plan is called probate. And probate is a process during which your assets are transferred to your heirs after your death. Probate is slow. In Minnesota, probate takes a minimum of 6 to 12 months. Oftentimes, it even takes longer than that, something like 18 months. And the truth is, we'd like it to go faster, but it just can't. It's intentionally a slow process. There are waiting periods where creditors have the opportunity to come forward kind of at their leisure. They have 4 months to come forward. There are built-in delays to make sure that, you know, this creditor is paid and this information is there and all of these different things. It makes for a very slow process where all of the assets are just hung up. And this can be really difficult if you have a business, if you have a home that has running costs on it, things like utilities or a mortgage that you're still paying or real estate taxes. All of that continues to accrue when your estate is going through probate. And it doesn't get resolved until the house gets sold or the house finally gets transferred out, which again, oftentimes can't happen until 6 months after you've passed away. So you can kind of imagine what that would look like. And that's why probate is also very costly. There are attorney's fees and executor's fees, appraisal fees, and court filing fees, bond premiums. There are all these different fees that contribute to the cost of probating, of bringing through the probate process your estate, to the point where we estimate here in Minnesota that probate costs something like 3 to 6% of the gross value of your estate. And just to put that into perspective, if all that you have is a house worth $400,000, and I understand to a lot of us that's a very nice house, to some of us that's where we're at right now, or you know, maybe that's where we were at, and our house is worth even more. Or maybe we don't own a home, but just keeping this as an example in mind, if all that you own is a home worth $400,000, then you already have a probate that's going to cost somewhere between $12,000 and $24,000. That's the 3 to 6% estimate of what probate costs. And more likely, I would say, if all that you have is that house worth $400,000, it's probably going to be towards the higher end. It's probably going to be something like $20,000 to get through probate. And we'll have a chance here in a little bit to actually calculate your probate estate based on just some back of the envelope math about your estate. Probate's also public. So this is the last will and testament of Anna Nicole Smith. And the reason that I'm able to access this is because wills are totally public. And again, having a will doesn't avoid probate. In fact, we have this really goofy saying in the estate planning world, where there's a will, there's a probate. If you are relying on a will to transfer your property to the people that you love, then there's going to have to be a probate to read that will, interpret that will, and actually enforce the provisions of the will. If you have minor kids, and those minor kids are receiving either because you don't have a plan in place or because you have a simple will that is gifting things to the kids, or you have set up beneficiary designations where the minor kids are going to receive. And they're going to receive everything at the age of 18 or 21, and they're going to receive everything unprotected all at one time. And I think we all know stories about kids receiving too much money at too young of an age and how it can kind of spoil kids' financial understanding and sense of finances when they receive too much money at a young age. So here's a chance to calculate your probate estate. And what I have on the screen may seem like a very wealthy person. It may seem like a very modest estate. Wherever you're at, you can apply this to your own estate. What I've done here is collect some items that generally don't pass by beneficiary designation. So I haven't included here life insurance or retirement accounts that do pass by beneficiary designation. Instead, I have things like real estate, so the home and a rental property, or maybe it's a cabin. I have furniture and household goods. I have automobiles, stocks, bonds, and bank accounts. And then I have a business interest as well that's worth about $100,000. And all of these things together add up to $850,000. And you can get 5% of that number very quickly, which is between that 3 to 6% estimate for what the cost of probate is. You can get 5% by moving the comma over one place. So you have the number 85,000 and then cutting that number in half. And that's how I got 42,500 as seen on the right side of the screen. And again, you could apply this for your own estate and get an estimate of about what you could expect probate to cost. Even if you do nothing else, if you own a home, try to think about what the fair market value of your home is and try and estimate what about 5% of the gross of transferring that house through probate, try and estimate about what that might cost. Just to add a little wrinkle here, if you have minor kids and you have them listed as beneficiaries on life insurance or retirement accounts, they cannot start paying out immediately to minors. And instead of paying out immediately to minors, they actually have to go through a process called conservatorship, where somebody steps up and takes those assets and dictates how they should be distributed out. Again, this is assuming that you don't have a plan in place or you just have a very simple will in place. But here you can see when you add in that cost of conservatorship, it can really balloon the cost, balloon the assets that are subject to the probate and conservatorship procedure, and really balloon the costs of probate and conservatorship as well. I see someone asking here, if you die with no assets, who pays the probate fees? And that's a really good question. If you truly die with no assets, or the assets are outweighed by the debts, then you have what's called an insolvent estate. And so your creditors just get paid to the fullest extent that you have assets. Everything is prorated based on the debts that you owe. If you have no assets, if you have no real estate, and you have nothing, your total assets total less than $75,000, there's actually a simple process that you can go through, or that your heirs can go through, called an affidavit for collection of personal property, in order to collect your personal property and lay claim to it and transfer it by that means. So it doesn't actually have to go through the probate process in that case, as long as, again, you're under $75,000 and you have no real estate. And the probate fees are estimates based on a combination of other fees, things like court filing fees, attorney's fees, appraisal fees and bond premiums, and personal representative or executor's fees, all these different fees. And so if you have assets that have little value, then a probate may just not be done. It may just not be worth going through the probate because there's not enough money in it to pay for the number of different expenses that the probate would incur. And so the assets might just eventually be lost and end up with the Department of Unclaimed Property instead. Good question. So this is the good news, is we've talked a lot about probate, and we've talked a lot about the expenses and everything of probate. But the good news is there is a foolproof way to avoid probate. And the foolproof way of avoiding probate is by fully funding a living trust. And what does that mean exactly? Well, a trust is an agreement. And the very simplest form of trust that you can have is one person hands property to another person and says, this is what I want you to use that property for. And the person that they handed the property to says, yes, I agree to use it for that. In this example, this person is called the settlor, the person who starts with the property, and they hand the property to the person called the trustee. And the trustee is going to hold that property in trust following the rules that the settlor laid out, okay? When I talk about a living trust, I'm talking about what's also known as a revocable trust. Revocable, meaning that you can revoke it or amend it at any time. You have complete control because you're both the settlor and the trustee, as well as the person who gets to benefit from your trust. That's what a living trust is, okay? So when you're putting assets in, when you're talking about funding a living trust, what that means is that all of your assets either have to go into your trust or they have to be pointed at your trust so that they go into your trust after you pass away. So things like investment accounts, if you have a brokerage account or a mutual fund, you own mutual funds or that kind of thing, you want to retitle that investment account so it's actually in the name of the trust. For bank accounts, you go to the bank and you sign new signature cards so that those bank accounts are now in the name of the trust. Real estate, real property, you execute deeds in order to transfer that property into the name of your trust so that your trustee is holding on to that real estate as opposed to you holding on to that real estate in your personal name. And by having this trustee hold on to it, when you pass away, you're the trustee originally, but when you pass away, a successor trustee can step up into your shoes and deal with that property just like you could have during your lifetime. That trustee can have control over it. They just need to follow the rules that you laid out during your lifetime in the trust agreement. Stock and bond certificates are transferred into the trust. Personal property is assigned into the trust by an assignment of personal property. And then life insurance and retirement accounts, you change the beneficiary designations so that they flow into the trust after you pass away. And that's the way that you fully fund a living trust. It's very important. It's often missed by other estate planning attorneys or not completed because a lot of estate planning attorneys see it just as the client's duty. That all the estate planning attorney wants to do is write the document, write the agreement, and then they send the client out the door and tell them to fully fund their trust. That's not serving clients. It's important to have very explicit, very clear direction about how to fund the trust, and I make sure to give that to my clients, and this is what that looks like for each different asset. Okay. Let's talk a little bit about estate taxes. And here is a place where I usually get to give people some pretty good news. This is an example. This is a very generous, somebody who's done very well for themselves, clearly. They also have some pretty substantial life insurance holdings that help to elevate the assets that are going through this person's estate. In this case, they have over $5 million. And what's important to know here is that there's a federal estate tax and a Minnesota estate tax. There's also exemptions on the federal level and on the state level. So for the federal estate tax, the rate can be up to 40%, but your first $12.06 million doesn't have any estate tax attached to it. In fact, if you're married, you actually get to double that number. So it's actually your first $24 million doesn't have any estate taxes that are attached to it. On the state level, we're not quite as lucky. The Minnesota estate tax exemption is $3 million. So as long as you have less than $3 million, you pay nothing in estate taxes. Once you get above $3 million, however, you do start to pay, and you start to pay at a rate that ranges from 13% up to 16%, depending on how high above $3 million you are. This number does not double automatically if you're married. You can make that number double, but you have to have some estate planning in place in order to make sure that things are handled in the right way, and that you are able to double that estate tax exemption here in Minnesota. So certainly, if you're close to that $3 million number, you want to reach out to, I hope that you'll reach out to me, but reach out to an estate planning attorney who can help you and give you guidance on exactly how to deal with that, deal with the estate tax here in Minnesota. I see somebody saying, or somebody asking, does a living will have to be done a certain amount of time before it can go into effect? If I die a week after living will is done, will it be honored? And so a living will, there are a couple terms that I just want to clarify. A living will is often part of a healthcare directive, and it's where you lay out what your wishes are for your healthcare. And there doesn't have to be, there's no baking in time for that kind of living will, that as soon as you execute it, your healthcare providers and your healthcare agent needs to abide by the directions that you've given them, provided that they know that you've put those directions out there somewhere. But my guess is that you're probably asking about, living trust. Okay, perfect. So a living trust, what's important is that you need to get that living trust funded. And that does take some time. It takes some time to make the trips to the bank, to write to your life insurance company and change beneficiary designations, to write to your retirement account and change beneficiary designations. Truth is, a lot of this can be done online now, so it can be done very quickly. And I try to guide and help my clients in doing it as quickly as possible so that it is effective and allows them to avoid probate. But we always build in to the estate plan what's called a pour over will. And a pour over will, what it does is it says, if I have any assets in my personal name when I pass away, put those assets into my trust and let the trust govern what happens to those assets. And we do that as kind of a backup method. So if you pass away within 1 week and you didn't have enough time to get all of your assets funded into the trust, that pour over will can put the assets into the trust. The only bad news there is, again, you're planning with a will, which means that you have to go through probate. Those assets that didn't get put into your will have to go through, or didn't get put into your living trust, have to go through the probate process in order to get put into your trust. And it's a simpler probate because all it's doing is putting those assets into your trust. But unfortunately, it does require probate if you pass away that quickly before you've funded your trust. Great question. All right. Will your assets be lost to the state? Does anyone have any idea how much money is currently in our State Department of Unclaimed Property? So over $700 million right now. And across the United States, it's over $58 billion in state departments of unclaimed property. And a big way that money gets there is that somebody passes away and the heirs and the fiduciaries, the agents of that person aren't aware of and aren't able to collect all of the assets that person had during their lifetime. And this is especially true nowadays with electronic statements turned on. We used to be able to go through a person's mail and find out where they banked at and get bank statements that showed exactly where the person was banking. But now with electronic statements, if you don't get access to that person's email, you may miss a bank account. You may miss something that's out there. Stock certificates or stock ownership is something that is commonly missed and is commonly not found. And in fact, it's a personal example to me because my grandfather passed away in 2001, and my family did everything that they could to collect all of his assets and make sure that everything went to my grandmother. But some stock certificates were missed, and those are still held in the State Department, in the Minnesota Department of Unclaimed Property. My family has been trying to reclaim those and to get them back and to distribute them out. But it's very difficult. It can be very difficult to work through all of the forms and work through all of the agencies and all of the institutions in order to get the money back at that point. It's best to avoid this. And the best way to avoid this is by having a full inventory of your assets before you pass away, so that all of your assets are clear, and where they are and what they look like and in what amounts they are is clear to your heirs and is clear to the people that you love, so that nothing gets missed. And that's really important. It's something that I help my clients with, that I help my clients to take care of. And it's also something that I keep a record of for my clients, so that when something happens to them, the kids can come to me and I can help them to make sure that they are able to find everything and that nothing gets lost to the State Department of Unclaimed Property. Okay, this is really cool. When you give an inheritance to somebody, you can make that inheritance, you can turn it into a real treasure chest. And what I mean when I say that is you can give your kids a gift called asset protection over the inheritance that you're giving them. Asset protection means that their inheritance can be protected from things like a spouse in a divorce or a creditor in a bankruptcy. It can completely shield that asset so that it's not accessible for that divorcing spouse or for that creditor in a bankruptcy. It's really a fantastic thing that you can do. It's something that they can't do for themselves. And people have tried doing what are called first-person asset protection trusts, but the truth is they just don't tend to work, especially here in Minnesota. We have some really strict laws about them. But because it's an inheritance, because it's something they're receiving from somebody else, it's considered a third-person trust, and you're able to build in much stronger asset protection for them, so that they can enjoy the money, as opposed to a divorcing spouse or a creditor enjoying that money on their behalf. Okay, we're going to talk here a little bit about incapacity, and the person that's pictured on the screen, her name is Terri Schiavo, and I'm sure many of us remember the story of Terri Schiavo. Terri suffered a cardiac event and was left in a vegetative state. And this was back in the mid-2000s. It was a really tragic story where her husband thought this isn't how Terri would want to live. Terri wouldn't want to continue living in a vegetative state. It's not clear that she can interact with people. Terri would want to be taken off of life support and permitted to pass away. But her parents had a different view of what Terri would want. Her parents thought Terri is having some interaction. She seems to be responding to some stimuli. We're not totally clear that Terri is completely gone. Sure, she's in this vegetative state, but it seems like maybe she's interacting with us a little bit. And we believe that Terri would want to be kept alive in this vegetative state going forward, that we shouldn't cut off life support. And so there was this big conflict. There was this big issue between the husband and between the parents about who should have the final say. And there were court cases at the state level, all the way up to the US Supreme Court, deciding what should happen with Terri Schiavo. Eventually, Terri was taken off of life support, and she did quickly pass away after being taken off of life support. The ex-husband, or the husband, ended up winning out. Terri's case is very sad, and the conflict in the court and the fighting is very sad, and it didn't have to be that way. You can document who you want to have acting as your healthcare agent, and you can document exactly the kinds of decisions that you would want that person to make on your behalf. And that is truly a gift. And trust me, I've seen situations where nobody's sure what to do. It is a great gift that you can give your family if you can give them some certainty about what your wishes are in a moment like Terri Schiavo had, where she was in a vegetative state. All right. So we've talked about a lot of things here today. We've talked about probate. We've talked about guardianship of minor children. When we talked about probate, we talked about the time that it takes to go through that probate process, and we talked about the cost and the public nature of probate. We talked about incapacity, and we talked about who can make healthcare decisions for you. Similar to that is who can make financial decisions for you and what should those financial decisions look like. We talked about taxes, estate taxes, and whether you might be subject to estate tax. We talked about unclaimed property as well. And so talking about all of these things, you're probably asking now, what can you do today to do the right thing for your family? And what should it cost to plan right? And I do see here that that there's a question, are beneficiaries responsible for any debt of the deceased? And no, the debts of the deceased terminate with the deceased. There are other laws in other nations and that kind of thing, but here in Minnesota in particular, in the United States and in Minnesota, it is understood that the beneficiary should not be responsible for the debts of the deceased. It doesn't necessarily mean that you get to receive without having to pay the creditors of the deceased or the debts of the deceased, but we don't believe that beneficiaries should be responsible for paying off debts that the deceased took out during their life. So here are your options. If you think that you need to do something, if it seems like you need to get something taken care of, you can either do it yourself or you can work with a lawyer. And keep in mind that not all lawyers are the same. So how do you choose? Would you benefit from working with a lawyer, or is this something that you can do yourself? And here are some things that you might consider. If you own more than just your personal belongings, things like cars, clothing, jewelry, and furnishings, if you own real estate, if you own more than $75,000 in possessions, then you would probably benefit from working with an attorney in order to get this taken care of. If you want to ensure that the people you love stay out of court and out of conflict and have someone to turn to when something happens to you, then you want to work with an attorney. You want to work with a counselor that they can turn to after you've passed away, who can help them through that legal process. If you want a kids protection plan, which includes the short-term guardianship, long-term guardianship, and more planning documents to make it really clear what you want to have happen with your minor kids, or you want to avoid probate or estate taxes, or you want to protect your children's inheritance in something like an asset protection trust, then you have to work with a lawyer in that case. Those are things that only a lawyer has access to and can do. If you want to guarantee that your plan is going to work when your family needs it to work, then you really have to work with an attorney. And I always tell this story. I had bought new fishing rods to go fishing with my son, and they shipped to us the rods and reels without any fishing line on them. Not a big deal. I ordered some fishing line separate and set about winding the fishing line onto the rod and reel. And I thought that I had everything going just right. It seemed like I was filling up the spool just fine and everything didn't look tangled or anything like that. But when I went to snip the line, after I had finally, put enough, what I thought was enough line on, all of a sudden that fishing line started jumping off of the spool. And I still don't know what I did wrong. Maybe somebody can put in chat if they know where I made a mistake. But I ended up with this huge tangled mess of fishing line on the table in front of me. Not a big deal. That was a do-it-yourself project where clearly I failed, but I found out right away that I had failed. The only cost of my failure was about 30 cents in fishing line that I was able to just snip off, and the rest that stayed on the reel ended up working fine. I was able to go fishing with my son that day, and I was able to clean everything up myself. I didn't have to rely on somebody else to clean things up for me. The reason that I tell that story is it's kind of the opposite of estate planning. When you do estate planning, if you make a mistake, you're not going to find out about it right away. In fact, you're never going to find out about it. Your family is going to be the one who ends up finding out about it. And at that point, you're not going to be there to clean up the mess. And it's not just going to cost 30 cents of fishing line. It's going to cost thousands and thousands of dollars in order to make sure that to get everything cleaned up and to get everything resolved. In fact, it may not even get resolved. If assets go to the wrong person, or assets are, your estate plan has inadvertently excluded somebody that you wanted to have included, there's just not a resolution to that. Your wishes are going to be carried out based on the documents that you prepared. And if the documents that you prepared exclude somebody, well, that's just a tough situation for that person who is excluded. And I know nobody wants that. I know nobody wants that kind of terrible negative experience. And so I really counsel, obviously I'm an interested party, but I really counsel against trying to do it yourself with an estate plan. And I really encourage you to work with a lawyer. Again, keeping in mind that not all lawyers are the same. And I want to revisit this quote that I talked about earlier. Again, this wasn't said about me, but someone has to graduate at the bottom of the class was said about another estate planning attorney who is practicing, again, under what I call a faulty model. I call it the planning for death model. And this is really the typical estate planning experience when you approach an estate planning attorney and want to work with them. Or if it's not, a lot of times it's not even an estate planning attorney, it is a family law attorney, but they dabble in estate planning on the side. Or it's a business attorney, or it's a litigation attorney, but they do a little bit of estate planning. And unfortunately, they just don't get the best results for their clients because they're just dabbling, and this is what it looks like. The typical experience, you're going to have form documents, and they're just going to feel like kind of set it and forget it documents. Your name will be plugged in a number of places, and maybe the names of your family will be plugged in a number of places. But that's about it. That's about as much customization as you typically get with those form documents from a typical attorney practicing under the planning for death model. Typical experience isn't going to keep money out of the Minnesota Department of Unclaimed Property. Most attorneys just don't see that as their mission or as their job to make sure that all of your assets transfer and all of your assets go to the people that you want to receive them. Typical experience may avoid probate, but it may not. And the truth is that a probate kind of benefits the attorney who wrote that plan. If the attorney gets to collect not just for writing your plan for you, but they also get to bring your estate through the probate process in 10 years or 20 years, then they kind of get two paychecks from that client. It's an ugly thing. And I don't think, I know a lot of estate planning attorneys and they care and they want your estate plan to work. But I also know that there are some estate planning attorneys who just plan for probate and just know that they're going to bring their client's family through the probate process down the road, and they're okay with that. And that's just the way that they plan and the way that they do estate planning. It's not the way that I do estate planning. I don't think that that's a good way to plan for people when they want things to just be simple and easy and inexpensive for their family. Typical experience probably isn't going to keep the family out of conflict. It doesn't contemplate all the family dynamics and deal with the family dynamics in a way that's going to keep them out of conflict. It's only going to focus on money, not your stories, those kinds of intangible assets, things like your values and stories that so often are the most important things that you can share with the people that you love. Typical experience is going to leave assets to heirs unprotected. Most attorneys just aren't building in that kind of asset protection over the assets that you can build in with an inheritance. Typical experience isn't going to include ongoing legal guidance. There are going to be hourly fees for any future needs. And that makes it really difficult to have a relationship with your attorney. If you know that you picking up the phone and telling your attorney, guess what? I just had my first grandchild born, or I just had my first great-grandchild born, means that that attorney is going to start the clock and is going to start billing you. That's not a good way to build a relationship. And it is really important that you have a relationship with your attorney to make sure that you're updating them about changes in your family, changes in your assets, and that your attorney can update you about changes in the law so that you get your documents updated if that's what needs to happen. Typical experience is also not going to adequately protect the kids. Most attorneys will write a long-term guardianship nomination into a will, but they won't write it into a separate document, and they won't write that short-term or that temporary guardianship nomination, which is so important if the police show up and need to know where the kids can go. It's so important to have that temporary guardianship document in place. And the typical experience is really going to leave you with the question, is this going to work when I need it to work? And that's not a question that you should ever have when you work with an estate planning attorney. Planning with me is totally different, and I call it planning for life. It's a totally different experience. First off, I charge flat fees. I have flat fee packages, and you get to choose the package. You get to choose the fee that you're going to pay. And that's not like a goodwill donation. I have these different packages, and I'll provide some guidance and I'll provide some help, but it has to match your finances. It has to match your goals in what you want to provide and take care of your family. Planning with me means keeping your money out of the hands of the state. Nothing's going to go to the Department of Unclaimed Property. We'll make sure that we have all of your assets inventoried so that everything gets where you want it to go. Planning with me means protecting your kids totally, both in the temporary or short-term immediate context and in the long-term context. Planning with me means keeping your family out of court and out of conflict. I think that is so important. And if you ask me, one of the biggest reasons that I have gone into and stayed in estate planning is because at heart, I'm a peacemaker. And I've seen how families can be torn apart by a bad estate plan or by no estate plan at all. And I know how harmful it can be to families, and I hate to see it. I would much rather keep families together, make the peace, and avoid that court and conflict in the family. Planning with me means that you're going to know that you've made the right decisions. I don't just size you up when you come in the room and then write a plan for you. I'm going to educate you, and I'm going to empower you to make decisions all the way through your estate plan, so you know what your estate plan says, and you know that it says exactly what you want it to say. Planning with me means protecting the family money from outsiders. It's that asset protection that you can build in for your kids or your loved ones that is so valuable down the road. Planning with me means a lifetime of guidance and protection, because I'm not going to charge you hourly fees when you pick up the phone and tell me, great news, my first grandchild has been born, or great news, my first great grandchild has been born. I want to hear that, and I want to be able to inform you what that means for you. And if there are changes to your documents, there would be a fee at that point. But I want to keep the lines of communication open between us, and I want to hear from you by email, by phone. I want to hear from you, and I want to know what's going on in your life, so that I can provide guidance and I can provide advice based on what's going on in your life. Planning with me means that you know that your plan is going to work when your family needs it to work. And again, this is really a gift that you're giving to the people that you love the most. It's a gift that you're giving so that things will be simple when you're gone. So what should this cost? What should it cost to plan right? Well, this planning is going to save your family at least $12,000 if all that you have is a house worth $400,000. And if you have assets over $3 million here in Minnesota, then it's going to save your family at least 13 cents on the dollar for every dollar in excess of $3 million. A typical death plan with a typical estate planning attorney is going to cost a minimum of $1,500. And again, it's almost going to be guaranteed that it's not going to keep your family out of court and conflict. It's not going to ensure your assets aren't going to the State Department of Unclaimed Property. It's only going to cover your money, not your intangible assets, things like your values, insights, stories, and experience, those most important intangible assets. Or you can meet with me, a personal family lawyer, and you can learn specifically what your family needs, and you can even choose your own fee again, and that fee is likely to range somewhere between $2,000 to $8,000. And I can tell you, most people fall at about $4,000 for a completely customized, fully laid out, revocable trust-based plan, living trust-based plan that avoids probate. And I want to make this really easy for you. And so I'm going to do a couple of things here. I want to post the link to my scheduling. Oh my goodness, but I lost it. There it is. And this is the link to my calendar so that you can see what's available. So click on that link in the chat and then pull it up and click on Family Wealth Planning Session, because I want to offer you that Family Wealth Planning Session for absolutely free. It has a value of $750 because it's a 2-hour long session with me where we'll talk about everything. We'll talk about your family, we'll talk about your assets, we'll talk about guardianship and probate and incapacity planning. We'll talk about estate taxes. We'll talk about how you want your kids to receive. We'll talk about so many things in that session, and we can talk about exactly what would happen based on either the estate plan that you have written right now, or if you don't have an estate plan written, we can talk about what would happen based on the estate plan that the state has written for you. It's a no obligation, free meeting, but I do want you to do some homework before you attend that session with me. So again, this is an absolutely free gift I want to give you just for being here tonight, educating yourself about this topic. And as long as you'll commit to doing a little bit of homework before we meet, I really want to give you this $750 family wealth planning session absolutely free. The other gift that I want to give you is $250 towards the estate plan, the estate planning package of your choice, if you'll just reserve your appointment by the end of the week. Now, what I mean by the end of the week is by the end of the day on Saturday. If you get onto my calendar, and people who have clicked over already, you can probably see you're not going to get onto my calendar in October, or there's no space in my calendar in October. There's already only limited selections in November and December. And the reason for that is I only help a limited number of clients every month. I give my clients a lot of my attention and a lot of my care. And so there are only so many people that I can help in any given month. And I limit the number of appointments that I have to limit that number of people that I'm able to help. But if you click over, take a look at my calendar, and if you just book that appointment by the end of the week, the appointment doesn't have to be by the end of the week. The appointment could be in February or whenever. But if you just make sure that you get it booked before the end of the day Saturday, you take that next step to get that family wealth planning session booked, I'm really happy to give you $250 off. And the reason for that, estate planning is a momentum thing, and you've probably experienced this. It starts on your to-do list, and then it falls lower and lower and lower to the point where you just don't get to it. But you've started the momentum here tonight. You've taken this step, you are educating yourself, and I want to reward you for that. But also I want to help you keep the momentum going. If part of my motive in giving you this $250 is I hope that you'll book your appointment by the end of the day on Saturday. And that means that I'll have less follow-up that I need to do. I won't have to pick up the phone and say, why didn't you book an appointment with me? I won't have to follow up by email and say, look, I just really want you to get this appointment. It's still free. Please sign up. Not having to do that follow-up, and the idea of rewarding you for being here and helping you to keep the momentum is very worth the $250 towards the plan of your choice there. I see somebody asking a question, what if the people we trust to take care of our kids are not here in the US? That's a fantastic question. In that case, it is just very important that you get that long-term guardian named in a document, but that you also have some short-term guardian who is here in the United States and who can take care of the kids until your long-term guardians are able to come and collect them. And so that short-term guardian, we can talk about this in an individual session. Could be somebody like a friend, could be somebody like a neighbor, could be somebody like one of the kids' friends from school, their parents, something like that. Could be an older sibling that they have who can watch them, could be a cousin. It could be all these different people, but it's really important that you have somebody that is somewhat local who can come and stay with the kids, or who can take the kids in for a short period of time until those long-term guardians can be contacted and pick them up. So what does working with me look like? My clients are overwhelmingly positive. And a big part of that is that I make sure that I educate and empower my clients to make the decisions themselves. I guide them in the decisions, but I make sure that they can make the decisions themselves. And I make it really simple for them. We can meet virtually for most of our meetings. We can meet virtually for our initial consultation that we do together. When we sign documents, we have to sign those documents in ink and in person. And so for that, I generally travel to my clients. The only thing that needs to happen, you need to find 2 witnesses who can come and be present with us, but that could be a neighbor, that could be a couple of friends, it could be any number of people, and we can talk about that. But I make it really simple because we meet virtually for the first meeting. I travel to you and we can sign documents. I try and take all of the complication out of the process by being a great guide and making sure that you are educated and empowered all the way through. So those people are in Vietnam. The long-term guardians are in Vietnam. Are they getting the visa to come to the US to take care of our kids? That's a really good question. There are some particulars there that I think that we would need to work out. There are some particulars about whether the kids are sent over to Vietnam and collected there in Vietnam, whether those guardians are, what it looks like to be able to have those guardians come here and be able to collect the kids here on U.S. soil and then bring them back over to Vietnam. There's some real particulars there that we should talk about, but I hope that you'll bring those to a family wealth planning session so that we can talk about it in more detail and more specifics, and also so that I can do a little bit of research and get you a clearer answer on exactly what that would look like. Here are some things that people have said about working with me, and I'm not going to read through these. You can read through them if you want to. But I do want to talk a little bit about this family wealth planning session and what it looks like and what you can expect. Again, the family wealth planning session can be totally virtual. We'll start by getting acquainted with each other a little bit so that you don't feel like you have to jump into decision making right away. And then we're just going to have a conversation. We're just going to talk about things. And I'm going to ask you some questions. I'm going to ask you questions like, who would be the person to collect everything if something happened to you? And what would you want to have happen if you became incapacitated? Who would you want being able to make decisions about your health? Who would you want making decisions about your finances? What would probate look like for you? And that's an answer. That's a question that I get to answer, is based on your assets, based on your family, based on where you're living. I can talk about what probate would look like for you and what the process in that court is going to look like. Are you going to owe estate taxes? And we'll talk about that. And we'll talk about what the numbers are and how you can start doing some planning to minimize the estate tax burden that your heirs are going to feel. And how do you want the people that you love to receive the assets that you want them to receive? And do you want them to be protected from things like a divorcing spouse? Do you want them to receive everything outright, just a quick check to them and everything is resolved? Do you want them to receive in what's called ages and stages over a period of time so that the money is stretched and you're, it's more certain that they're taking good care of the money? We'll talk about all of those things in the family wealth planning session. After the family wealth planning session, I confirm everything with you in a confirmation document, and I actually draft your documents from that confirmation document. Again, I can actually travel to you for your signing meeting. That signing meeting is where your documents become effective. We can get those documents in place in just 4 to 6 weeks after we meet that first time. It can all be very quick and, again, very simple for you. Then after that signing meeting, there's actually a third meeting called the Family Wealth Legacy Interview. And that meeting is where we get to capture some of your values and some of your stories, some of the things that are most important to you that you want to capture and share with the people that you love, the people coming after you. So your next step is to schedule that free family wealth planning session. And I really hope everybody has clicked on the link and taken a look at my calendar so that they can find a time that works for them. And again, I know that the times on there might be a little bit select. It may be a little difficult to find a time. I encourage you to try and jump in and find a time that's going to work, or a time that will work best for you and for, if you're married, for your spouse as well, so that you can attend it together. It's a virtual meeting, so hopefully that makes it easy to join me if you're working from home, or if you can have a day where you work from home, something like that, and we can have that family wealth planning session together. And again, I want to give you $250 towards the plan of your choice, so that you can enjoy that discount towards that custom and tailored estate plan that I can help you to get into place and get effective. And that's the next step. And again, I hope that you're clicking through right now. I'll keep an eye over here on the chat and on the Q&A in case people have questions that they want me to ask. Some questions that I often get, one question that I often get is, what kind of estate plan should an 18-year-old have in place? This is something that's really important for people who are sending kids to college for the first time. Maybe some of us have kids who are in their first year at college. It's very important that they have a power of attorney in place and a healthcare directive in place, as well as something that's called a HIPAA waiver. And the HIPAA waiver allows you to access their healthcare information. Now that they've turned 18, you no longer have access to their healthcare information. You no longer have access to things like their bank accounts in the same way that you did when they were just 17 years old. Now that they're 18, now that they're an adult, it's assumed that they want to keep those things private unless they have chosen to disclose them to you. So something like a HIPAA waiver can give you access to that healthcare information. A healthcare directive can allow you to make healthcare decisions on their behalf if they need somebody to make those decisions on their behalf. Power of attorney allows you to do things like write checks from their accounts if those checks need to be written, and they can't do it themselves. So those are some really important documents. I know most 18-year-olds are not going to have over $75,000 in assets, or going to own real estate. And so it's unlikely that an 18-year-old is really going to strongly need a will or a trust or anything like that. But a power of attorney, healthcare directive, and HIPAA waiver are some things that I think are really important and that I help my clients to make sure that their kids have in place when I do planning for my clients. Another thing that I often get questions about is, and I see actually there's a question here, does the safe deposit box get closed down immediately after death, or can signer of box get in anytime? When somebody passes away, if whoever has the rights to act as the agent on behalf of the deceased can get access to that safe deposit box. So generally, the bank is not going to close that safe deposit box. If the payments are kept current, they're going to keep that safe deposit box open. So it's not going to get closed down until some agent acting on behalf of the deceased goes with the key and is able to collect everything from the safe deposit box and then eventually close it down. And so I've seen what this looks like. Oftentimes they can be very picky about making sure that you have the key, and if there are two keys, making sure that you have both keys. So you want to keep both keys in a similar area where they can easily be found. You want to make sure that there are notes, that there's a safe deposit box, and that they know where the safe deposit box is held, and that they know approximately what the contents are. You don't want to keep wills in a safe deposit box because it can be difficult to access the will. If you don't know if there's a will, for one thing, it can be difficult to access it. It's not clear who the agent should be if you don't have the will, because the best agent for that purpose is the personal representative, or the executor who's named in the will is the most natural person to go and collect that safe deposit box. So I'm probably going into too much detail, but in general, the agent of the deceased can go and collect things from the safe deposit box. If they don't have clear authority to collect things from the safe deposit box initially, they can at least go and get an inventory of what's in the safe deposit box. And if there's a will there, then they can collect that will in order to probate it and make sure that they get the power to actually go and collect the other contents of the safe deposit box. Good question. I have had it come up before in practice, unfortunately, it can be a little bit sticky sometimes. That's the unfortunate part. Not seeing other questions. Again, I really hope that you've had a chance to click through to my calendar. I've tried to make my availability there somewhat broad so that people can find a time that works for them. And I do hope that you'll find a time that works for you and that you'll keep the momentum moving forward on this estate planning to do. If my parent becomes incapacitated and I know that they have done a power of attorney form, how do I get it activated? Also, what if a person is becoming mentally infirm? How do you get approval to activate it? That's a fantastic question. So the power of attorney forms that I write generally define incapacity in a specific way. And some powers of attorney become effective immediately. So we have in Minnesota what's called a short form power of attorney, and the short form power of attorney is immediately effective. That means that the agent, the attorney, in fact, can start acting immediately as the person's agent. They can start making financial decisions even before the person has become incapacitated. And so if that's the case, if it's immediately effective, you could start acting immediately. You might need something like an affidavit of attorney, in fact, that says this person created a power of attorney. You really should have a copy of that power of attorney showing it. But then in the affidavit of attorney, in fact, you say, I believe that this power of attorney is still in effect. It hasn't been revoked. It hasn't been replaced. I am the person who's named as the agent or the attorney, in fact, and I am now exercising my authority under this power of attorney. And that is what activates it. That's what gives you the power to start acting as the attorney, in fact. If, on the other hand, the power of attorney is conditioned on incapacity, and I often draft the powers of attorney that way as well, then you're going to have to look at the power of attorney to find out how incapacity is defined. And oftentimes, the incapacity will be defined either as one doctor signing off and saying, yes, this person no longer has the ability to manage their finances and needs help. Or it might be two doctors who need to sign off and say this person no longer can manage their own finances. It could also be handled in a number of different ways. I know I've drafted incapacity provisions where it is a decision of the kids. If a majority of the kids say that mom needs help with her finances, well, now then the oldest child or whoever is named as that attorney, in fact, oftentimes it's the oldest child, can now step in because a majority have said that yes, mom needs help. So you're going to have to get that power of attorney in order to know exactly, and you're going to have to get that power of attorney in order to start acting under it anyway. Each power of attorney may have slightly different powers that they authorize as well. Almost always there will be the power to deal with real estate. Almost always there will be the power to deal with bank accounts. But some of the other powers can be there and may not be there. Things like the ability to gift isn't always included in a power of attorney. The ability to plan for Medicaid or medical assistance isn't always included. The ability to trade stocks or to trade options or make calls or puts, things like that aren't always included as powers that the power of attorney has. So you have to look at it really carefully and see what your powers are, see how you activate it. Again, it's likely activated either initially when it's first signed or by this determination of incapacity. And then you have to make sure that it's what's called a durable power of attorney too, which means that it continues in power after the person is incapacitated. And for estate planning purposes, almost all powers of attorney done for estate planning purposes are durable. They do continue after the person becomes incapacitated, but it is something that you want to make sure it was drafted the correct way, and that it makes that really clear. All right. Any other questions here tonight? We are a little over the hour mark, but I want to stay on and answer any other questions that have come in. If you've already booked your appointment, you can feel free to either stay on and hear me answer some more questions, or drop off if you choose to. If you haven't booked an appointment yet, I encourage you to, again, take a look at my calendar and find a time that works for you, in order to get that appointment scheduled, so that you can keep this momentum going. You can keep the process going, and make sure that you get this done. All right. If your home is part of a living trust, what happens if you downsize and move to another home? Great question. Again, a living trust, you have complete control over the assets that are in a living trust. And that means that you can put assets into it by giving them to the trustee, and then you can ask for those assets back and take those assets back out of the trust as well, which means that either you can take the house out of the trust in order to sell it, or you can actually sell it directly from the trust. You could just order that trustee, to sell it, and the trustee will go and complete the deal using what's called a trustee's deed in order to complete that sale. So not a problem. It's still completely your asset as long as it's in a living trust. Irrevocable trusts are different. An irrevocable trust, if you put your home into an irrevocable trust, which is often used for things like planning for nursing home care, it's also called sometimes a 5-year trust, or a Medicaid asset protection trust, or a medical asset protection trust. If you put your home into something like that, you're not going to have access to it in the same way that you would with a living trust or a revocable trust, which is what we've mostly been talking about. If you can revoke it, it's a revocable trust or a living trust. If you can't revoke it once it's put into place, it's an irrevocable trust. And so if you put your house into something like an irrevocable trust, you have given up control of that house. You might still be able to live in the house and enjoy the house during your lifetime, and the house will eventually pass on to the people that you've named in that irrevocable trust after you have, likely after you've passed away. But in an irrevocable trust, you have given up the ability to do things like downsize and move to another home. And there can be some flex around that. If you name the right trustee, if you have a trustee that is a child or something like that, sometimes you can give them some direction, and they'll listen and decide to sell the one property and buy another. But generally that's the case, is you give up control with an irrevocable trust. With a living trust, you don't give up control, you maintain control. Are there disadvantages to a living revocable trust? That's a fantastic question. There are a couple of disadvantages. Planning with a living revocable trust is more expensive than not doing any planning. It's certainly more expensive than not doing any planning. It's also more expensive than just a will-based plan. That's just the reality. Is it's more expensive. There's another document that has to be written. There's counseling that has to be done on exactly how to fund that living trust and make sure that everything gets in there. So there is a little bit of a disadvantage there. From the perspective of passing assets after you pass away, there really aren't disadvantages. It's really pretty much upside at that point. Things are kept private. Things can go much more quickly. Things have less cost after you've passed away in distributing things out. And most people want things to be private. They want their assets, they want the distributions that are being made to be private after they're gone. But if you know that there's going to be conflict in your family, you just know that one of your kids is going to be a shark and is going to try and get as much as they can, and they're going to pick on their siblings, they're going to do this and that, then in that case, you may not want things to be private. You may want a court involved to make sure that your other kids are protected from that one child who might cause difficulty for the other kids. It's a sad situation, but I have seen it before where it makes more sense to get a court involved than to try and give one of the kids who may not have the strength, the fortitude to stand up to this sibling, that having the court involved means that they don't have to have as much backbone. But generally, that's not the case. Generally, people want things to be handled privately. They want things to be handled at the lowest cost possible, as simply as possible, without having to go through the court process. And a living trust accomplishes that. The only other disadvantage that I can think of is that, again, it's not going to work unless you fund it. And that means taking your bank accounts that you own in your personal name and putting those bank accounts in the name of the trust, giving them to your trustee so that your trustee can oversee them. And again, your trustee is going to be you during your lifetime, as long as you have capacity. But it means taking your home and putting your home in the trust and making sure that that's done. Taking your personal property and putting your personal property in the trust. Making sure that your retirement accounts and life insurance proceeds eventually are directed to that trust. So there's some work that needs to be done, but again, I try and make it as easy, as simple as possible, and I try to do it in the most cost-effective way for my clients to make sure it's as approachable as possible for everybody. So hopefully that answers that question. There are some disadvantages, but they are limited, especially compared to the amount of value that they provide. When will we be able to hear this recording? I would like one of my kids to hear this before I sign up for a visit with you in case they have questions. Absolutely, completely understood. I'm going to try and get the recording out tonight. It takes some time to process and download, and then it takes some time to process on the upload. I upload it to YouTube where it can be accessed at any time. And then I'll shoot out an email to everybody. Again, I'll try to have that done. If not tonight, then it'll be done first thing in the morning tomorrow so that everybody can have access to it. And I completely understand about wanting the kids to be able to review this and hear this before you meet with me. You know, in that case, I might recommend that you find a spot on my calendar and then have them review. And if it doesn't feel like a good fit, that's okay. You know, I understand, and I'm happy to talk to kids. I'm happy to talk to anybody. I'm an open book. I want people to know, you know, what I'm doing and to be transparent with the way that I'm working. But yes, it's I know that my time is limited on my calendar, and I don't want anyone to miss out when they want to be able to find and have a time on my calendar. Thanks for all the information. I'll be talking to my parents and go over this with them. That's fantastic. That's great. And I hope that you'll share the recording with them. I will have another webinar that I'm doing like this in November, and then a final one for the year in December as well. And I think the December one is already set for December 6th. It's another Wednesday evening like this. I'm not sure when the November one will be exactly, but I will plan to do that as well. Thank you for everything. Great job. Oh, thank you very much. And thank you for attending tonight. I am going to go ahead and wrap this up here. It doesn't seem like there are any other questions that are coming in. I want to just tell everybody that I really appreciate you being here tonight. I really appreciate and commend you for educating yourself on this topic. I know that this isn't easy, and I know that this can be confusing, and it might even be frustrating. Again, I understand that, but you're doing the right thing by being here and educating yourself. And again, I promise you, if you want me to, I can help to make this an easy process for you and a painless process for you, so that you can really give the people that you love this gift. You can give them the gift of having everything be simple as possible after you're gone, because I know that's what a lot of us want. So thank you, everybody. Thanks for being in attendance here tonight, and I hope you have a great rest of your night. Take care.